Severino, and it's doing PR and campaign ads for Republican judicial nominees. It got single $17 million donation in the Garland-Gorsuch contest. It got another single $17 million donation to support Kavanaugh. Somebody, perhaps the same person, spent $35 million to influence the makeup of the United States Supreme Court. Tell me that's good. And then over here, you have a whole array of legal groups, also funded by dark money, which have a different role. They bring cases to the court. They don't wind their way to the court, Your Honor. They get shoved to the court by these legal groups, many of which ask to lose below so they can get quickly to the court to get their business done there. And then they turn up in a chorus, an orchestrated chorus of amici. Now, I've had a chance to have a look at this, and I was in a case, actually, as an amicus myself, the Consumer Financial Protection Board case. And in that case, there were 11 amicus briefs filed, and every single one of them was a group funded by something called Donors Trust. Donors Trust is a gigantic identity scrubbing device for the right wing so that it says Donors Trust is the donor without whoever the real donor is. It doesn't have a business. It doesn't have a business plan. It doesn't do anything. It's just an identity scrubber. And this group here, the Bradley Foundation, funded 8 out of the 11 briefs. That seems weird to me when you have amicus briefs coming in little flotillas that are funded by the same groups but nominally separate in the court. So I actually attached this to my brief as an appendix. Center for Media and Democracy saw it, and they did better work. They went on to say which foundations funded the brief writers in that CFPB case. Here's the Bradley Foundation for $5.6 million to those groups. Here's Donors Trust, $23 million to those brief writing groups. The grand total across all the donor groups was $68 million to the groups that were filing amicus briefs, pretending that they were different groups. And it's not just in the Consumer Financial Protection Board case. You might say, well, that was just a one-off. Here's Janus, the anti-labor case that had a long trail through the court, through Friedrichs and through Knox and through other decisions. And SourceWatch and ProPublica did some work about this. Here's Donors Trust and Donors Capital Fund, and here's the Bradley Foundation, and they totaled giving $45 million to the 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 groups that filed amicus briefs pretending to be different groups, and both of the lawyer groups in the case. Funded by Donors Trust, funded by Bradley Foundation in Janus. This is happening over and over and over again, and it goes beyond just the briefs. It goes beyond just the amicus presentations. The Federalist Society, remember this group that is acting as the conduit and that Donald Trump has said is doing his judicial selection? They're getting money from the same foundations. From Donors Trust, $16.7 million. From the Bradley Foundation, $1.37 million. From the same group of foundations total, $33 million. So you can start to look at these and you can start to tie them together. The legal groups, all the same funders over and over again, bringing the cases and providing this orchestrated chorus of amici. Then the same group also funds the Federalist Society over here. The Washington Post wrote a big expose about this, and that made Leonard Leo a little hot, a little bit like a burned agent. So he had to jump out, and he went off to go and do anonymously funded voter suppression work. Guess who jumped in to take over the selection process in this case for Judge Barrett? Carrie Severino made the hop. So once again, ties right in together. So Center for Media and Democracy has done a little bit more research, Here's a Bradley Foundation memo that they've published. The Bradley Foundation is reviewing a grant application asking for money for this orchestrated amicus process. And what do they say in the staff recommendation? It is important to orchestrate, their word, not mine, important to orchestrate high-caliber amicus efforts before the court. They also note that Bradley has done previous philanthropic investments in the actual underlying legal actions. So Bradley is funding, what do they call, philanthropically investing in the underlying legal action and then giving money to groups to show up in the orchestrated chorus of amici. That can't be good. And it goes on, because they also found this email. This email comes from an individual at the Bradley Foundation, and it asks our friend Leonard Leo, who used to run the selection process, is there a 501c3 nonprofit to which Bradley could direct any support of the 2 Supreme Court amicus projects other than Donors Trust? I don't know why they wanted to avoid the reliable identity scrubber Donors Trust, but for some reason they did. So Leonard Leo writes back on Federalist Society address. So don't tell me that it isn't Federalist Society business. On Federalist Society, on his address, he writes back, yes, send it to the Judicial Education Project, which could take and allocate the money. And guess who works for the Judicial Education Project? Carrie Severino, who also helped select this nominee running the Trump Federalist Society selection process. So the connections abound. In the Washington Post article, they point out that the Judicial Crisis Network's office is on the same hallway in the same building as the Federalist Society, and that when they sent their reporter to talk to somebody at the Judicial Crisis Network, somebody from the Federalist Society came down to let them up. This, more and more, looks like it's not 3 schemes, but it's 1 scheme, with the same funders selecting judges, funding campaigns for the judges, and then showing up in court in these orchestrated amicus flotillas to tell the judges what to do. On the Judicial Crisis Network, you've got the Leonard Leo connection, obviously. She hopped in to take over for him with the Federalist Society. You've got the campaigns that I've talked about, where they take $17 million contributions. That's a big check to write, $17 million. To campaign for Supreme Court nominees. No idea who that is or what they got for it. You've got briefs that she wrote. The Republican senators filed briefs in that NFIB case signed by Ms. Severino. The woman who helped choose this nominee has written briefs for Republican senators attacking the ACA. Don't say the ACA's not an issue here. And by the way, the Judicial Crisis Network funds the Republican Attorneys General. It funds RAGA, the Republican Attorney General's Association, and it funds individual Republican Attorneys General. And guess who the plaintiffs are in the Affordable Care Act case? Republican Attorneys General. Trump joined them because he didn't want to defend, so he's in with the Republican Attorneys General. But here's the Judicial Crisis Network campaigning for Supreme Court nominees, writing briefs for senators against the Affordable Care Act, supporting the Republicans who are bringing this case, and leading the selection process for this nominee. Here's the page off the brief. Here's where they are. Mitch McConnell, and on through the list. Senator Collins, Senator Cornyn, Senator Hoeven, Senator, who's still here? Marco Rubio. It's a huge assortment of Republican senators who Carrie Severino wrote a brief for against the Affordable Care Act. So this is to me, pretty big deal. I've never seen this around any court that I've ever been involved with, where there's this much dark money and this much influence being used. Here's how the Washington Post summed it up. This is a conservative activist behind-the-scenes campaign to remake the nation's courts, and it's a $250 million dark money operation. $250 million is a lot of money to spend if you're not getting anything for it. So that raises the question, what are they getting for it? Well, I showed the slide earlier on the Affordable Care Act and on Obergefell and on Roe versus Wade. That's where they lost. But with another judge, that could change. That's where the contest is. That's where the Republican Party platform tells us to look at how they want judges to rule, to reverse Roe, to reverse the Obamacare cases, and to reverse Obergefell and take away gay marriage. That is their stated objective and plan. Why not take them at their word? But there's another piece of it, and that is not what's ahead of us, but what's behind us. What's behind us is now 80 cases, Mr. Chairman, 80 cases under Chief Justice Roberts that have these characteristics. One, they were decided 5-4 by a bare majority. Two, the 5-4 majority was partisan in the sense that not one Democratic appointee joined the five. I refer to that group as the Roberts Five. It changes a little bit, as with Justice Scalia's death, for instance, but there's been a steady Roberts Five that has delivered now 80 of these decisions. And the last characteristic of them is that there is an identifiable Republican donor interest in those cases. And in every single case, that donor interest won. It was an 80-0, 5-4 partisan rout, ransacking. And it's important to look at where those cases went, because they're not about big public issues like getting rid of the Affordable Care Act, undoing Roe versus Wade, and undoing same-sex marriage. They're about power. And if you look at those 80 decisions, they fall into four categories over and over and over again. One, unlimited and dark money in politics. Citizens United is the famous one, but it's continued since with McCutcheon, and we've got one coming up now. Always the five for unlimited money in politics, never protecting against dark money in politics, despite the fact that they said it was going to be transparent. And who wins when you allow unlimited dark money in politics? A very small group. The ones who have unlimited money to spend and a motive to spend it in politics. They win, everybody else loses. And if you're looking at who might be behind this, let's talk about people with unlimited money to spend and a motive to do it. We'll see how that goes. Next, knock the civil jury down. Whittle it down to a nub. The civil jury was in the Constitution, in the Bill of Rights, in our darn Declaration of Independence. But it's annoying to big corporate powers, because you can swagger your way as a big corporate power through Congress. You can go and tell the president you put money into to elect what to do. He'll put your stooges at the EPA. It's all great until you get to the civil jury, because they have an obligation, as you know, Judge Barrett. They have an obligation under the law to be fair to both parties, irrespective of their size. You can't bribe them. You're not allowed to. It's a crime to tamper with a jury. It's standard practice to tamper with Congress. And they make decisions based on the law. If you're used to being the boss and swaggering your way around the political side, you don't want to be answerable before a jury. And so one after another, these 85-4 decisions have knocked down, whittled away at the civil jury, a great American institution. Third, first was unlimited dark money. Second was demean and diminish the civil jury. Third is weaken regulatory agencies. A lot of this money, I'm convinced, is polluter money. The Coke Industries is a polluter. The fossil fuel industry is a polluter. Who else would be putting buckets of money into this and wanting to hide who they are behind donors' trust or other schemes? And if you're a big polluter, what do you want? You want weak regulatory agencies. You want ones that you can box up and run over to Congress and get your friends to fix things for you in Congress. Over and over and over again, these decisions are targeted at regulatory agencies to weaken their independence and weaken their strength. And if you're a big polluter, a weak regulatory agency is your idea of a good day. And the last thing is in politics, in voting. Why on earth the court made the decision a factual decision, not something appellate courts are ordinarily supposed to make, as I understand it, Judge Barrett, the factual decision that nobody needed to worry about minority voters in pre-clearance states being discriminated against or that legislators would try to knock back their ability to vote. These 5 made that finding in Shelby County against bipartisan legislation from both houses of Congress, hugely passed on no factual record. They just decided that that was a problem that was over, on no record, with no basis, because it got them to the result that we then saw. What followed? State after state after state passed voter suppression laws. One so badly targeting African Americans that the 2 courts said it was surgically tailored to get after minority voters. And gerrymandering, the other great control. Bulk gerrymandering, where you go into a state, like the Red Map Project did in Ohio and Pennsylvania, and you pack Democrats so tightly into a few districts that all the others become Republican majority districts. And in those states, you send a delegation to Congress that has a huge majority of Republican members, like 13-5, as I recall, in a state where the 5, the party of the 5, actually won the popular vote. You've sent a delegation to Congress that is out of step with the popular vote of that state, and court after court figured out how to solve that, and the Supreme Court said, nope, 5-4 again, nope, we're not going to take an interest in that question. In all these areas where it's about political power for big special interests and people who want to fund campaigns and people who want to get their way through politics without actually showing up, doing it behind donors' trust and other groups, doing it through these schemes, over and over and over again, you see the same thing. 80 decisions, Judge Barrett. 80 decisions, an 80-0 sweep. I don't think you've tried cases, but some cases, the issue is bias and discrimination. And if you're making a bias case as a trial lawyer, Lindsey Graham is a hell of a good trial lawyer. If he wanted to make a bias case, Dick Durbin's a hell of a good trial lawyer. If they wanted to make a bias case and they could show an 80-0 pattern, A, that's admissible, and B, I'd love to make that argument to the jury. I'd be really hard-pressed to be the lawyer saying, no, 80-0 is just a bunch of flukes. All 5-4, all partisan, all this way. So something is not right around the court. And dark money has a lot to do with it. Special interests have a lot to do with it. Donors' trust and whoever's hiding behind donors' trust has a lot to do with it. And the Bradley Foundation orchestrating its amici over at the court has a lot to do with it. So I thank you, Judge Barrett, for listening to me now a second time. And I think this gives you a chance for you and I to tee up an interesting conversation tomorrow. And I thank my colleagues for hearing me out.
Thank you, Senator Whitehouse. Senator Cruz.
Oh, Mr. Chairman, can I put 3 letters in unanimous consent?
Without objection.
Thank you.
Thank you, Mr. Chairman. Judge Barrett, welcome. Congratulations on being nominated. Congratulations on enduring the confirmation proceedings. And I think it is a particularly good thing we've made it through what I guess you would call the top of the lineup of the questioning. And some of the smartest and frankly most effective questioners on the Democratic side. And I think it speaks volumes that Collectively, they've had very few questions for you,
And most effective. He's getting back.
and virtually none calling into question
Pointing that out to.
your credentials,
Make the
which
cut.
are impeccable,
Didn't make the cuts.
your record, and what I think has been an extraordinary life you've led. So that should be the source of great satisfaction in terms of the scholarly record and judicial record that you've spent a lifetime building. I want to start by asking you a question. Why is the First Amendment's protection of religious liberty, why is that important?
Well, I think it's broadly viewed that the framers protected and ratifiers protected the free exercise of religion because, for reasons that we all know from history of persecuted religious minorities fleeing to the United States, that enshrining that protection, it was one of the Bill of Rights because it was considered so fundamental.
And why does that matter to Americans? What difference does that make in anybody's life?
Well, I think all of the Bill of Rights, each and every one of them, is important to Americans because we value the Constitution, including religious liberty.
Well, how about the free speech protections of the First Amendment? Why are those important?
So that minority viewpoints can't be squashed, so that it's not just the majority that can speak popular views. You don't really need the First Amendment if what you're saying is something that everybody wants to hear. You need it when people are trying to silence you.
And how about the Second Amendment? Why is the right to keep and bear arms important?
Well, we've talked about Heller earlier this morning, and what Heller tells us is that the Second Amendment protects an individual right to bear arms for self-defense.
Well, I think all of those rights, and I agree with you, the entire Bill of Rights is incredibly important to Americans. I also think what is really striking about this hearing today and also yesterday is that Senate Democrats are not defending what I think is really a radical agenda that they have when it comes to the Bill of Rights. And the topics they're discussing today have little bearing to the rights that are really at issue and in jeopardy at the Supreme Court. And so let's take a few minutes to go through them. First of all, we've had some discussion of Roe versus Wade. You have declined to give an opinion on a matter that might be pending before the court. That is, of course, the same answer that every single sitting justice has given when he or she was sitting in the same chair you are. It is mandated by the judicial canons of ethics. Whether one is a nominee of a Democratic president or a Republican president, that has been the answer that has been given to this committee for decades. But I do think it is interesting that our Democratic colleagues, number one, don't discuss what would actually happen if there came a day in which Roe versus Wade were overruled, which is namely that it would not suddenly become the case that abortion was illegal, but rather it would revert to the status of the law as it's been for nearly 200 years of our nation's history, which is that the question of the permissibility of abortion is a question for elected legislatures at the state levels and at the federal level. And it is difficult to dispute that there are a great many jurisdictions, including jurisdictions like California and New York, who, even if Roe versus Wade were no longer the law of the land, their elected legislatures would almost certainly continue unrestricted access to abortion with virtually no limitations. What I find interesting, though, is that our Democratic colleagues do not discuss what is really the radical position of the most liberal justices on the Supreme Court, which is that no restrictions whatsoever are permissible when it comes to abortion. Yesterday, one of the Democratic senators made reference to the case Gonzalez versus Carhartt. I'm quite familiar with that case, and I represented Texas and a number of other states as amici in that case. That case concerned the constitutionality of the federal ban on partial birth abortion. That was legislation that passed Congress, was signed into law, that made the really gruesome practice of partial birth abortion illegal. Overwhelming majority of Americans believe partial birth abortion should be prohibited, even those who identify as pro-choice. A significant percentage of Americans don't want to see that gruesome practice allowed. Supreme Court, by a vote of 5-4 in Carhartt versus Gonzalez, upheld the federal ban on partial birth abortion. That means there were 4 justices ready to strike it down, ready to conclude that you can't ban partial birth abortion, that you can't ban late-term abortion. And by the way, other restrictions that are at question include parental consent laws, parental notification laws. None of our Democratic colleagues want to talk about the justices they want to see on the court would strike down every single reasonable restriction on unlimited abortion on demand that the vast majority of Americans support. How about free speech? Well, we've heard quite a bit about free speech. The senator from Rhode Island just gave a long presentation, complete with lots of charts. I'll say a couple of things on free speech. First of all, our Democratic colleagues, when they address the issue of so-called dark money and campaign finance contributions, are often deeply, deeply hypocritical and don't address the actual facts that exist. Here are some facts. Of the top 20 organizations spending money for political speech in the year 2016, 14 of them gave virtually all of their money to Democrats, and another 3 split their money evenly. So only 3 of the top 20 gave money to Republicans. What did that mean in practice? That meant the top 20 super PAC donors contributed $422 million to Democrats and $189 million to Republicans. Those who give these impassioned speeches against dark money don't mention that their side is funded by dark money with a massive differential. The senator from Rhode Island talked about big corporate powers without acknowledging that the contributions from the Fortune 500 in this presidential election overwhelmingly favor Joe Biden and the Democrats, without acknowledging that the contributions from Wall Street in this election overwhelmingly favor Joe Biden and the Democrats. It's an awful lot of rhetoric about power. But it gets even more interesting when you look at Supreme Court nominations. We just heard an attack on the Federalist Society, a group that I've been a member of for over 25 years. I joined as a law student. It's a group that brings conservatives, libertarians, constitutionalists together to have robust discussions about the Constitution and about the law. What's interesting is nowhere in the Senator of Rhode Island's remarks was any reference to a company called Arabella Advisors, which is a for-profit entity that manages nonprofits, including the 1630 Fund and the New Venture Fund. Now, what on earth are those? Those sound like awfully dark and confusing names. Well, according to the Wall Street Journal this Sunday, in the year 2017 and 2018, those entities reported $987.5 million in revenue. That's nearly $1 billion. We heard a lot of thundering indignation at what was described as $250 million of expenditures. In this case, you've got $1 billion. The senator of Rhode Island said that much money, much of which is dark money that we don't know who contributed it, he asked, what are they getting for it? And by the way, one of the things they're getting for it is a group called Demand Justice, a project of those entities, spent $5 million opposing Justice Brett Kavanaugh and has just launched a 7-figure ad buy opposing your confirmation. So all of the great umbrage about the corporate interests are spending dark money is wildly in conflict with the actual facts that the corporate interests that are spending dark money are funding the Democrats by a factor of 3 to 1 or greater. A fact that doesn't ever seem to be acknowledged. But not only that, what was Citizens United about? You know, it's interesting, most people at home, they've heard about Citizens United. They know it makes Democrats very, very upset. But they don't actually know what the case is about. Citizens United concerned whether or not it was legal to make a movie criticizing a politician. Specifically, Citizens United is a small nonprofit organization based here in D.C. that made a movie that was critical of Hillary Clinton. And the Obama Justice Department took the position that it could punish Citizens United for daring to make a movie critical of a politician. The case went all the way to the U.S. Supreme Court. At the oral argument, there was a moment that was truly chilling. Justice Sam Alito asked the Obama Justice Department, "Is it your position, under your theory of the case, that the federal government can ban books?" And the Obama Justice Department responded, "Yes. Yes, it is our position that if the books criticize a political candidate, a politician, the federal government can ban books." As far as I'm concerned, that is a terrifying view of the First Amendment. Citizens United was decided 5-4. By a narrow 5-4 majority, the Supreme Court concluded the First Amendment did not allow the federal government to punish you for making a movie critical of a politician. And likewise, that the federal government couldn't ban books. 4 justices dissented. 4 justices were willing to say the federal government can ban books and can ban movies and presumably could ban books as well. When Hillary Clinton was running for president, she explicitly promised every justice she nominated to the court would pledge to overturn Citizens United. By the way, Hillary Clinton said she would demand of her nominee something you have rightly said that this administration has not demanded of you, which is a commitment on any case as to how you will rule. Democrats have shown no compunction in expecting their nominees to make a promise. Here's how I'm going to vote on a pending case. Judicial ethics be damned. Or how about the Second Amendment? We've heard some reference to the Heller decision. Senator from Connecticut yesterday talked about reasonable gun control and gun safety provisions. Well, that, of course, was not what was at stake in the Heller decision. Number one, majority decision in Heller, Justice Scalia's opinion, acknowledges reasonable provisions, things like prohibitions on felons in possession are permissible. Your opinion in the Cantor decision likewise acknowledged that restrictions preventing dangerous criminals from receiving firearms are entirely consistent and permissible under the Second Amendment. But the issue at Heller was much more fundamental. It was whether the Second Amendment protects an individual right to keep and bear arms at all. The vote in Heller was 5-4. By a vote of 5-4, the majority struck down the District of Columbia's total prohibitions on owning an operative firearm in the District of Columbia. The argument of the 4 dissenters was not what our Democratic colleagues talk about here. It wasn't some reasonable gun control provisions are okay. That was not the argument of the dissenters. That question we can actually have a reasonable debate on. Reasonable minds can differ on what the appropriate line should be, what are reasonable laws there, but that was not what was at issue at Heller. The position of the 4 dissenters was the Second Amendment protects no individual right to keep and bear arms whatsoever, but merely a, quote, collective right of the militia, which is fancy lawyer talk for a non-existent right. 4 justices would have ruled that way, 1 vote away. the consequences of the court concluding that there is no individual right under the First Amendment would mean you and I and every American watching this would lose your Second Amendment right. It would mean the federal government, the state government, the city could ban guns entirely, could make it a criminal offense for any one of us to own a firearm. And no individual American would have any judicially cognizable right to challenge that. That is a radical reading of the Constitution. That is effectively erasing the Second Amendment from the Bill of Rights. And Hillary Clinton likewise promised in 2016 that every justice she nominated would commit to voting to overturn Heller. They were big on litmus tests. And Joe Biden, although he refuses to answer just about anything about whether or not he's going to pack the court, he did tell the American people the voters don't deserve to know whether he's going to pack the court. Truly a statement of disrespect and contempt for the voters, unusual in our political process. One vote away from the Second Amendment being erased from the Bill of Rights. None of our Democratic colleagues admit that that is their agenda, and yet those are the justices that Democratic presidential nominees are promising they will appoint. Justices who will take away your right to criticize politicians, justices who will allow censorship, justices who will allow movies and books to be banned, justices who will erase the Second Amendment from the Bill of Rights. And how about religious liberty? Religious liberty is an issue near and dear to a great many of us. The right of every American to live according to your faith, according to your conscience, whatever that faith may be. Religious liberty is fundamentally about diversity. It's about respecting diversity, that whatever your faith tradition might be, the government is not going to trample on it. Religious liberty cases over and over again have been decided 5-4. The case of Van Orden versus Perry, a case I litigated, dealt with the Ten Commandments monument that stands on the state capitol grounds. It's been there since 1961 in Texas. An individual plaintiff, an atheist, a homeless man, filed a lawsuit seeking to tear down the Ten Commandments. The case went all the way to the U.S. Supreme Court. It was decided 5-4. 4 justices were willing to say, in effect, send in the bulldozers and tear down that monument because you can't gaze on the image of the Ten Commandments on public land. Another case, the Mojave Desert Veterans Memorial. This is a memorial erected to the men and women who gave their lives in World War I. It's a lone white Latin cross, simple and bare in the middle of the desert. I've been there on Sunrise Rock where it stands. The ACLU filed a lawsuit saying you cannot gaze on the image of a cross on public land, and the ACLU won in the district court. They won in the Ninth Circuit Court of Appeals. The federal courts ordered that Veterans Memorial to be covered up with a burlap sack with a chain on the bottom, and then a plywood box. When the case went to the U.S. Supreme Court, I represented 3 million veterans pro bono for free, defending that Veterans Memorial. We won 5-4, and there were 4 justices prepared to say, tear down the Veterans Memorial, and under the reasoning that they put forth, they were not far away from saying, bring out the chisels and remove the crosses and the stars of David on the tombstones of the men and women that gave their lives at Arlington Cemetery defending this nation. That is a radical view, and we're 1 vote away. That is utterly contrary to the text of the First Amendment, to the understanding of the First Amendment. When we argued the Ten Commandments case in the U.S. Supreme Court, there was more than a little bit of irony. In that, do you know how many times the image of the Ten Commandments appears in the courtroom of the Supreme Court? The answer to that is 43. There are 2 images of the 10 Commandments carved on the wooden doors as you walk out of the courtroom. You will soon be sitting looking at them. There are 40 images of the 10 Commandments on the bronze gates on both sides of the courtroom. And then, Judge Barrett, when you're sitting at the bench, above your left shoulder will be a frieze you know well, a frieze carved into the wall of great lawgivers, one of whom is Moses. He is standing there holding the 10 Commandments, the text of which is legible in Hebrew as he looks down upon the justices, and 4 justices were willing to say, in effect, bring out the sandblasters, because we must remove God from the public square. That is a profound threat to our religious liberty, and I would note that it doesn't just extend to public acknowledgments. It also extends to religious liberty. The Little Sisters of the Poor, our Catholic convent of nuns who take oaths of poverty, who devote their lives to caring for the sick, caring for the needy, caring for the elderly. And the Obama administration litigated against the Little Sisters of the Poor, seeking to fine them in order to force them to pay for abortion-inducing drugs, among others. It's truly a stunning situation when you have the federal government litigating against nuns. The Supreme Court decided the Hobby Lobby case, another case routinely denounced by Senate Democrats. The Hobby Lobby case concluded that the federal government could not permissibly force a Christian business to violate their faith. It reflected the religious liberty traditions of our country, that you can live according to your faith without the government trampling on it. You know what this body did, I'm sorry to say? Senate Democrats introduced legislation to gut the Religious Freedom Restoration Act. Religious Freedom Restoration Act, when it passed this body, passed with an overwhelming bipartisan majority. Senate Democrats, including Chuck Schumer and Joe Biden and Ted Kennedy, all voted for the Religious Freedom Restoration Act. Democratic President Bill Clinton signed the Religious Freedom Restoration Act. And yet, in the wake of the Hobby Lobby decision, this body voted on legislation to just gut the protections for religious liberty. And I'm sorry to say, every single Senate Democrat voted to do so. Not a single one, 0, would defend religious liberty. Joe Biden has already pledged, if he's elected, he plans to initiate again the attack on the Little Sisters of the Poor. You know, it's interesting, folks in the press like to talk about Pope Francis. And on some issues, Pope Francis has been vocal when it comes to the environment, when it comes to issues concerning immigration. The Pope has been vocal on issues that our Democratic colleagues like and agree with. The press is happy to amplify those views. Somehow missing from that amplification is acknowledgement that when the Pope came to the United States in Washington, he went and visited the Little Sisters of the Poor. Here in D.C., he went to their home here in D.C., and the Vatican explained he did so because he wanted to highlight their cause. That the federal government shouldn't be persecuting nuns for living according to their faith. That's what's at stake in these nominations. And you won't hear any of that from the Senate Democrats on this committee. That's why their base is so angry at your nomination, Judge Barrett, because they don't believe you are going to join the radical efforts to erase those fundamental rights from the Bill of Rights. I believe that issue, preserving the Constitution, preserving the Bill of Rights, our fundamental liberties, I believe is the most important issue facing the country in the November elections. And I think for those of us who value those rights, we should take solace in the fact that not a single Democrat is willing even to acknowledge the radical sweep of their agenda, much less defend it. They know it's wildly unpopular, and look, right at the heart of this is a decision many Democrats have made to abandon democracy. You see, most policies like Obamacare, policies like health care, most policies under our constitutional system are meant to be decided by democratically elected legislatures. Why? So they can be accountable to the people. So if the voters disagree, they can throw the bums out. But too many Democrats have decided today that democracy is too complicated. It's too hard to actually convince your fellow Americans of the merits of your position. It's much easier just to give it to the courts. Find 5 lawyers in black robes and let them decree the policy outcome you want, which makes your radical base happy, presumably makes the millions, if not billions, in dark money being spent for Democrats happy, without actually having to justify it to the American people. Judge Barrett, I'm not going to ask you to respond to any of that. But I do want to shift to a different topic, which is a bit more about you personally, your background. Judge Barrett, do you speak any foreign languages?
Once upon a time, I could speak French, but I have fallen woefully out of practice, so please don't ask me to do that right now.
You can be assured of that, because I had 2 years of high school French, and I suspect yours remains much better than mine. How about music? Do you play any instruments?
The piano.
Do you? How long have you played the piano?
Well, I played the piano growing up for 10 years, and now most of my piano playing consists of playing my children's songs for them and supervising their own piano practice. I look forward one day when I have more time to be able to choose some of my own music.
Now, do the kids do piano lessons as well?
The kids do piano lessons. Some of the older ones who are in high school have gotten so busy with sports and those things that they've stopped, but the younger children do.
Our girls are 9 and 12, and they both do piano lessons, and I will say, at least in our household, it is less than voluntary. One of the things Heidi and I found, particularly the last 6 months during COVID, which has been an extraordinary crisis, is just with 2 kids at home, that doing distance learning when schools were shut down was really hard for us with 2 children. For you and your husband, you've got 7 kids. How did y'all manage through the lockdowns and distance learning? What was that like in the Barrett household?
Well, it was a challenging time, as it was for every American. Our oldest daughter, Emma, who's in college, moved home at that point because she's at Notre Dame. It closed. So Emma obviously could manage her own e-learning, and our high school age children, Tess and Vivian, could too. But Jesse and I just tried to take a divide and conquer approach for the younger 4. And yeah, it was quite challenging, I assure you.
One part of your story that I find particularly remarkable and that I admire is the decision you made to adopt 2 children. You and your husband had 5 biological children, and you adopted 2 more. Both of your adopted children are from Haiti. Haiti is a country that has some of the most crushing poverty in the world. My brother-in-law is a missionary in Haiti, and actually Heidi and the girls just got back from Haiti a couple of weeks ago. I was curious if you would share with this committee and with the American people what led you and your husband to make the decision to adopt? It's I think, one of the most loving and compassionate decisions any family can make.
When Jesse and I were engaged, we met another couple who had adopted, in this instance, it was a couple who had adopted a child with special needs. And then we also met another couple who had adopted a few children internationally. And we decided at that point, while we were engaged, that at some point in the future, we wanted to do that ourselves. And I guess we had imagined initially that we would have whatever biological kids that we had decided to have and then adopt at the end. But after we had our first daughter, Emma, we thought, well, why wait? So I was expecting Tess when we went and got Vivian. So she and Tess function, we call them our fraternal twins. They're in the same grade. And it really has enriched our family immeasurably. And, you know, once we had adopted Vivian at that point, then we made the decision that we definitely wanted to adopt again. And so several years later, John Peter entered our family.
So your children have been wonderfully well behaved. I think you're an amazing role model for little girls. What advice would you give little girls?
Well, what I'm saying is not designed, my brother now has left, I was just thinking of what my dad told me before the spelling bee about anything boys can do, girls can do better. And since my sons are sitting behind me, I'll also say, but boys are great too.
Thank you.
Thank you. Senator Klobuchar.
Thank you very much, Mr. Chair. Welcome again, Judge. Since I have the draw to always follow Senator Cruz, I did want to make one thing clear after listening to that for a half hour, that Joe Biden is Catholic and he is a man of faith. And then I want to turn to something else, and that is that we need a reset here, in my mind, for the people at home, a bit of a reality check. That this isn't normal right now. We have to understand that what people are dealing with, that 7.7 million people have gotten this virus, that 214,000 Americans have died. And for people watching at home and wondering what we're all doing in this room right now, and maybe you're home because you lost your job, or maybe you got your kids crawling all over your couch right now. Maybe you're trying to teach your first grader how to do a mute button to go to school. Or maybe you've got a small business that you had to close down or that's struggling. We should be doing something else right now. We shouldn't be doing this. We should be passing coronavirus relief like the House just did, which was a significant bill that would have been a big help. And I think people have to know that right now. And whether you're Democrat, Independent, or Republican. And that's why I started out yesterday by telling people that they need to vote. Number two, some of my colleagues throughout this hearing on the other side have been kind of portraying the job that the judge is before us on as being some kind of ivory tower exercise. I think one of my friends called it related that you'd be dealing with the dormant commerce clause. Well, I'm sure that might be true, but we also know that this is the highest court in the land, that the decisions of this court have a real impact on people. And I appreciated, Judge, that you said that you didn't want to be a queen. I actually wouldn't mind being a queen around here, if the truth be known. I wouldn't mind doing it, and kind of a benevolent queen and making decisions so we could get things done. But you said you wouldn't let your views influence you and the like, but the truth is the Supreme Court rulings, they rule people's lives. They decide if people can get married. They decide what schools they can go to. They decide if they could even have access to contraception. All of these things matter. So I want to make that clear. And the third reset here that I think we need to have is that this hearing is not normal. It is a sham. It is a rush to put in a justice. The last time that we had a vacancy so close to an election was when Abraham Lincoln was president. And he made the wise decision to wait until after the election. The last time we lost a justice so close to an election. That's what he did. Today, we are 21 days from the election. People are voting. Millions of people have already cast their ballots. And I go to the words of Senator McConnell. The last time we had a situation in election year, he said, the American people should have a voice in the selection of their next Supreme Court justice. Therefore, this vacancy should not be filled until we have a new president. That set the precedent that so many of you have embraced, or at least you did a few years ago, and that is that in an election year, the people choose the president, and then the president nominates the justice. So why is this happening? Well, that's a good question. This guy, our president, he is the one that decided to plop a Supreme Court nomination in the middle of an election when people's health care is on the line with a case before the court on November 10th. So let's see what he said about the Supreme Court. Well, one of President Trump's campaign promises in 2015 was that his judicial appointments will do the right thing on Obamacare. You can see it right here. And in fact, Judge, just one day after you were nominated, this is like a few weeks ago, he said also on Twitter that it would be a big win if the Supreme Court strikes down the health law. So, Judge, my first question, do you think we should take the president at his word when he says his nominee will do the right thing and overturn the Affordable Care Act?
Senator Klobuchar, I can't really speak to what the president has said on Twitter. He hasn't said any of that to me. And what I can tell you, as I have told your colleagues earlier today, is that no one has elicited from me any commitment in a case or even brought up a commitment in the case. I am 100% committed to judicial independence from political pressure. So whatever people's, party platforms may be or campaign promises may be, the reason why judges have life tenure is to insulate them from those pressures. So I take my oath seriously to follow the law. And, I have not pre-committed, nor would I pre-commit to decide a case any particular way.
Okay, and I think this life tenure, this idea that you have, just for everyone out there, a job for life, makes this even more important for us to consider where you might be. And I know you have not said how you would rule on this case that's coming up right after the election, where the president had said it would be a big win if the Supreme Court strikes down the law. But you have directly criticized Justice Roberts in an article in my own state in one of the Minnesota Law School journals. It was in 2017. It was the same year you became a judge. And when Roberts writes the opinion to uphold the Affordable Care Act, you said he, quote, pushed the Affordable Care Act beyond its plausible meaning to save the statute. Is that correct?
Senator Klobuchar, I just want to clarify, is this the constitutional commentary publication that you and I discussed?
Yes,
'Cause
it
I haven't
is.
done that.
If
Okay.
that it is, but it's still a
No,
University of Minnesota law. Yes.
Okay, I just wanted to be sure because
Yeah,
I hadn't published in the
I
Minnesota
just,
Law Review.
again, did you ask that question? Did you say that he pushed the Affordable Care Act beyond its plausible meaning to save the statute?
One thing I want to clarify is you said that I criticized, Chief Justice Roberts, and I don't attack people, just ideas. So that was
Okay.
just designed to make a comment about his reasoning in that case, which as I've said before, is consistent with the way the majority opinion characterized it as the less plausible reading of the statute.
Okay, so you didn't agree with his reasoning in the case that upheld the Affordable Care Act?
What I said, and was this King versus Burwell or NFIB versus Sebelius?
That was NFIB versus Sebelius. I'll get to King versus Burwell in a second.
Okay. What I said with respect to NFIB versus Sebelius is that the interpretation that the majority adopted, construing the mandate to be a tax rather than a penalty, was not the most natural reading of the statute.
But it was
made no
still the
comment.
reading that Justice Roberts got to. Now, you also criticized, as you pointed out by bringing up King v. Burwell, another case where the court ruled in favor of the health law. This was in a 2015 National Public Radio interview. And you acknowledged that the result of people being able to keep their subsidies under the Affordable Care Act would help millions of Americans. Yet you praised the dissent by Justice Scalia, saying the dissent had, quote, the better of the legal argument. Is that correct?
I did say that, yes.
Okay, so then would you have ruled the same way and voted with Justice Scalia?
Well, Senator Klobuchar, one of the plus sides or the upsides of being an academic is that you can speak for yourself, that a professor professes and can opine, but it's very different than the judicial decision-making process. So it's difficult for me to say how I would have decided that case if I had to go through the whole process of judicial decision-making that I was describing this morning. Now, having been a judge for 3 years, I can say I appreciate greatly the distinctions between academic writing or academic speaking and judicial decision-making, such that a judge might look at an academic and say, easy for you to say, because you're not on a multi-member court, you're not constrained by stare decisis, you don't have real parties in front of you, consulting with litigants, consulting with your clerks.
Yes.
It's just a different process.
I viewed this one so interestingly because you were commenting on the public policy result, which you and my colleagues on the Republican side have said this shouldn't be about public policy, and you said, okay, that's okay, but then you were really clear on your legal outcome in terms of your view of whose side you were on. You were on Scalia's side, and of course, that was a side to not uphold the Affordable Care Act, which would have been kicked millions of people off their health care in effect because they would have lost their subsidies. And I just see this as interesting because of this kind of dichotomy they're trying to make between policy and legal. And my view is that legal decisions affect policy. I mean, I'm looking at people in my state that'll deal with this if the Affordable Care Act is struck down. Elijah from St. Paul, who was born with cerebral palsy. Because of the Affordable Care Act, he is now 16 and is a proud Boy Scout. Casey, whose brother lives in Alexandria, and he has chronic kidney failure, and he needs a transplant. Without the ACA, that'd be that. Or Burnett from the suburbs of St. Paul, whose daughter has multiple sclerosis, depends on benefits under the ACA. Liliana of Fridley, who has a 21-year-old son with autism and needs her children to be able to stay on her insurance until she's 26. Melanie, a senior from Duluth who's being treated for ovarian cancer and needs access to the Affordable Care Act. So my point is that these are real-world situations. And so I get that you're not saying how you'd rule on these cases. So what does that leave us with here to try to figure out what kind of judge you would be? And I was thinking last night of when I was growing up, we would go up to northern Minnesota, and we didn't have a cabin, but we had friends that did, and we would go on these walks in the woods with my mom, and she loved to show all the tracks on that path, whether they were deer tracks, and she'd have us figure out what they were, or elk, or maybe even a bear, and we would follow these tracks down that path. And you'd always think, is there going to be a deer around the corner that we're going to see? And very rarely was there one. But we would follow the tracks. And so when I look at your record, I just keep following the tracks. That's what I've got to do. And so when I follow the tracks, this is what I see. You consider Justice Scalia one of the most conservative judges in the history of the Supreme Court as your mentor. You criticized the decision written by Justice Roberts upholding the Affordable Care Act. That is, to me, one big track. Even if you didn't consider yourself criticizing him personally, you criticized the reasoning. You then said in another case about the Affordable Care Act that you would that you liked the legal reasoning, that he had the better legal argument, that Justice Scalia had the better legal argument. You have signed your name to a public statement featured in an ad, a paid ad, that called for an end to what it called, the ad called, the barbaric legacy of Roe v. Wade, which ran on the anniversary of the 1973 Supreme Court decision. You disagreed with long-standing precedent on gun safety, which said that felons shouldn't be able to get guns, something that was pretty important to me when I had my old job in law enforcement. This is something that Senator Durbin asked you about. You suggested that you agree with the dissent in the marriage equality case, Obergefell, that it wasn't the role of the court to decide that same-sex couples had the right to be married. I think this was in a lecture you gave where you said the dissent's view was that it wasn't for the court to decide. People could lobby in state legislatures. And all this takes me to one point as I follow those tracks down that path. And it takes me to this point where I believe, and I think the American people have to understand, that you would be the polar opposite of Justice Ginsburg. She and Justice Scalia were friends, yes, but she never embraced his legal philosophy. So that is what concerns me. And I want to turn to an area where I think Justice Ginsburg, who's seat we are considering you for was truly a hero, and that was the area of voting rights. And that was the area of elections. I think that, what did the president say here? He said, September 23rd, 2020, I think this, he means the election, will end up in the Supreme Court. And I think it's very important that we have 9 justices. I don't think how much clearer we can be. And as I said yesterday, I do not for a minute concede that this election is going to end up in the Supreme Court because people are voting in droves as we speak. But that is what is on the mind of the man who nominated you for this job. Then he said, on September 29th of 2020, I think I'm counting on them, he meant the court, to look at the ballots definitely. So, I know you said earlier in questions from Senator Leahy that you are not going to commit to whether or not you are going to recuse yourself for any kind of an election case. But I do want to point out that as the president has said these things, and as he has nominated you, that people are voting right now. They are voting, as I said, in droves. Do you know how many states where people are voting right now, Judge? I think one of my colleagues said it earlier.
I don't know.
It's more than 40 states. People are voting right now as we speak. I think something like 9 million votes have been cast. Do you think it is faithful to our democratic principles to fill a Supreme Court vacancy this close to an election when people are still voting?
Senator Klobuchar, I think that is a question for the political branches.
Okay. That's your right to answer in that way. Beyond this immediate election, I want to turn to the Supreme Court's critical role when it comes to the right to vote, this area where Justice Ginsburg was such a champion. Senator Durbin went over your dissent at length in Cantor v. Barr, where you drew a distinction between individual rights and civic rights. And you wrote that historically, felons should be disqualified from exercising certain rights, like the right to vote and to serve on juries. So my question is this next line, where you said, these rights belonged only to virtuous citizens. What does that mean?
Senator, I would need to look at the article to clarify, but as I'm sitting here, I don't think I said felons should lose voting rights. I think what I was talking about is that 14th Amendment. Yeah, that.
But it wasn't an article, just to be clear, right? This is your dissent.
Oh, my dissent.
Yeah, I think it's your dissent in Cantor v.
Yes, you're right.
And it says felons could be disqualified from exercising certain rights, like the rights to vote and serve on juries. But apart from that clause, you said these rights belong only to virtuous citizens. That's what I'm trying to understand what that means.
So the argument in the case, those who were challenging Heller and those who were arguing on the side of the government in the Cantor case is that the Second Amendment is a civic right. And that is how the Supreme Court itself framed the debate, as a distinction between civic rights and individual rights, with voting being a civic right. And in literature, in the historical literature, which was at play in that case.
Okay, but how would you define the word virtuous? Because it doesn't appear in the Constitution.
Well, Senator,
I'm just trying to know what that means, because we're living at a time where a lot of people are having their voting rights taken away from them. So what's virtuous?
Okay, well, Senator, I want to be clear that that is not, in the opinion, designed to denigrate the right to vote, which is fundamental. The distinction between civic and individual rights is one that's present in the court's decisions, and it has to do with a kind of a jurisprudential view of what rights are. And the virtuous citizenry idea is a historical and jurisprudential one. It certainly does not mean that I think that anybody gets a measure of virtue and whether they're good or not and whether they're allowed to vote. That's not
Okay.
what I said.
Okay, now let me ask you this in a different way, because now let's go to the real world here. So, in Justice Ginsburg's dissent in Shelby, where a 5-4 court struck down a key provision of the Voting Rights Act, she described the right to vote as a fundamental right in our democratic system. And I assume you agree with this, because you just said that, that's not good to her dissent. You agree with the concept that it's a fundamental right, because you just...
As I just said, yeah, the court has repeatedly said it was
Okay,
fundamental.
so she also wrote in her dissent that the Constitution uses the words right to vote in 5 separate places, the 14th, 15th, 19th, 24th, and 26th amendments. Each of these amendments, this is still her talking, not me, each of these amendments contains the same broad empowerment of Congress to enact appropriate legislation to enforce the protected right. The implication is unmistakable. Under our constitutional structure, Congress holds the lead rein in making the right to vote equally real for all U.S. citizens. Do you agree with Justice Ginsburg's conclusion that the Constitution clearly empowers Congress to protect the right to vote?
Well, Senator, that would be eliciting an opinion from me on whether the dissent or the majority was right in Shelby County, and I can't express a view on that, as I've said, because it would be inconsistent with the judicial rule.
Okay, so here's my problem. So you go out of your way in the case that Dick Durbin was discussing to make this distinction between voting rights and gun rights, but now you won't say whether or not you agree with Ginsburg. And so my view is, just based, again, following those tracks on this case, that you are most likely with the majority, but I know you're not going to answer this. But what I do want you to know is this, and this is where it gets interesting because of what Justice Ginsburg predicted in that dissent. According to the Brennan Center, over 20 states since that case came out that withdrew, that took away part of the protections from the Voting Rights Act, over 20 states have now made more restrictive voting laws than they did before that case. Doesn't that suggest to you that Justice Ginsburg had the better of the argument when she wrote that throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet? Do you think that that's true? And I mean, it seems to me that the proof is in the pudding. Like basically, this rainstorm that she said would come has come with all these states, including a number of them that my colleagues over there represent, have enacted stricter laws. Has it happened?
Senator Klobuchar, I want to clarify, you said I was answering Senator Durbin's questions about the Second Amendment, but refusing to answer yours. And so I just wanted to clarify that I had written Cantor versus Barr, and so that's why I was talking about it. But since I didn't write Shelby, I can't really talk about it. So anything that I've written about or talked about, I would be happy to answer your questions.
Okay. All right. But again, it just seems to me you are out of your way on that case. And this is a case that is so real for so many people right now. And that while you can say it's a fundamental right, the issue is that this case and the Voting Rights Act are so key. And let me just say why. We're talking about the entire foundation of our democracy here. For centuries, Americans have fought and died to protect the right to vote. And so what matters is not just what you say about its being fundamental, it's what you do. States like South Carolina, Texas, North Carolina, Louisiana, Tennessee have policies that make it harder for people to vote. And it's a real-world thing before the Supreme Court. In fact, back in May, when voters in Wisconsin were standing in line in the middle of a pandemic, in homemade masks, in garbage bags, in the middle of a rainstorm, just to exercise their right to vote, 70 of them got COVID, because we didn't know enough about it back then, because the president hadn't told us what he knew, and we didn't know enough to protect those voters. So it ends up at the Supreme Court. What did Justice Ginsburg do? When the Republican-appointed majority on the court ruled that voters in Wisconsin could not have more time to get their ballots in during the pandemic, she called them out in her dissent, in her blueprint for the future, and she said the majority opinion boggled the mind. So what boggles my mind? Well, 2 weeks ago, the U.S. Supreme Court reinstated the South Carolina requirement that mail-in ballots must have witness signatures. In the middle of a pandemic, you got to go and get a witness. In Texas, Republicans have argued that the pandemic wasn't a good enough reason to let people under age 65 vote by mail, despite the fact that over 42,000 Americans under 65 have died from COVID. And the governor right now is forcing that state to have only one ballot box per county, including in Harris County, where there are 4.7 million people. And for those of you that thought a judge took care of it a few days ago, he did. But then yesterday, 3 Trump-appointed judges came in and reversed that. So we're back to one ballot box for people to drop their ballots off in a county of 4.7 million people. In Tennessee, Republicans have tried to prevent ballot drop boxes. I know we had the Secretary of State as one of our witnesses at a Rules Committee hearing, and they have argued in court that COVID-19 is not a valid excuse to vote by mail. In North Carolina, the Supreme Court struck down a core component of the Voting Rights Act. What happened? Well, states like North Carolina passed laws that were so egregious to make it harder to vote that the Fourth Circuit struck down their law and noted that it targeted African Americans with almost surgical precision. So that is what the stakes are. And that is why not having Justice Ginsburg on the court right now is so frightening to so many Americans out there. And that is why we are asking you these questions about voting. So let me turn to another election question, gerrymandering. In 2015, Justice Ginsburg wrote the majority opinion in Arizona State Legislature for the Arizona Independent Redistricting Commission, holding that it was constitutional for the people of Arizona to amend the state constitution to establish an independent redistricting commission. Because of this case and Justice Ginsburg's opinion, many argue now that Arizona has fairer electoral maps. The decision was 5-4. Here's your example. And now Justice Ginsburg and Justice Kennedy are no longer on the court. My question is this: must state legislatures abide by their own state's constitution when exercising their authority under the Elections Clause?
Senator Klobuchar, that would be eliciting an opinion from me about whether I agreed or disagreed with the result in that case.
Okay,
And
is it constitutional for voters to amend a state constitution to establish specific processes for elections, like the voters in Arizona did to stop gerrymandering?
Again, you're asking me for a view on that particular case, and Justice Ginsburg herself gave the most famous articulation of the principle that constrains me from doing so, which is no hints, forecasts, or previews. So I can't express a view on precedent or on how I would decide any question that was provoked by the application of that precedent to a later case.
Okay, last week a contractor from outside of my state of Minnesota started recruiting poll watchers with special forces experience to protect polling locations in my state. This was clear voter intimidation. Similar efforts are going on around the country, solicited by President Trump's false claims of massive voter fraud, something that, by the way, many Republican leaders, including Michael Steele, the former head of the Republican Party, including Tom Ridge, including Governor Kasich, including sitting Senator Romney, have made very clear is not true. So as a result of his claims, people are trying to get poll watchers, special forces people, to go to the polls. Judge Barrett, under federal law, is it illegal to intimidate voters at the polls?
Senator Klobuchar, I can't characterize the facts in a hypothetical situation, and I can't apply the law to a hypothetical set of facts. I can only decide cases as they come to me, litigated by parties on a full record after fully engaging precedent, talking to colleagues, writing an opinion. And so I can't answer questions like that.
Okay, well, I'll make it easier. 18 U.S.C. 594 outlaws anyone who intimidates, threatens, coerces, or attempts to intimidate, threaten, or coerce any other person for the purpose of interfering with the right of such other person to vote. This is a law that has been on the books for decades. Do you think a reasonable person would feel intimidated by the presence of armed civilian groups at the polls?
Senator Klobuchar, that is eliciting, I'm not sure whether to say it's eliciting a legal opinion from me, because the reasonable person standard, as you know, is one common in the law, or just an opinion as a citizen, but it's not something really that's appropriate for me to comment on.
Okay. Here's one that I think is selection of electoral college electors. You know that each state has laws that dictate how electoral college electors are selected. Judge Barrett, in 1932, the Supreme Court in Smiley v. Home, a case involving my state, ruled that the Minnesota State Legislature could not change election rules unilaterally. Do you agree that the unanimous opinion in Smiley v. Home, which has never been questioned by any other Supreme Court case, is settled law?
Well, I'll say two things about that. First of all, I was not aware of that case, so you've taught me something.
Okay.
But secondly, I can't comment on the precedent, give thumbs up or thumbs down in Justice Kagan's words.
Okay, well, why don't we end there with precedent? I think that's a good way to end here. So you wrote in your 2013 Texas Law Review article that you tend to agree with the view that when a justice's best understanding of the Constitution conflicts with Supreme Court precedent or case law, it is, quote, more legitimate for her to follow her preferred view rather than apply the precedent. And I want to run through a few examples. So Brown v. Board of Education, as we know, that holds that the 14th Amendment prohibits states from segregating schools on the basis of race. So is that precedent
Yes.
that can't be overruled?
Well, that is precedent. And as I think I said in that same article, it's super precedent. People consider it to be on that very small list of things that are so widely established and agreed upon by everyone. Calls for its overruling simply don't exist.
Okay. Well, you also separately acknowledged that in Planned Parenthood v. Casey, the Supreme Court's controlling opinion talked about the reliance interest on Roe v. Wade, which it treated in that case as super precedent. Is Roe a super precedent?
How would you define super precedent?
I actually might have thought someday I'd be sitting in that chair. I'm not. I'm up here, so I'm asking you.
Okay, well, people use super precedent differently.
Okay.
The way that it's used in the scholarship and the way that I was using it in the article that you're reading from was to define cases that are so well settled that no political actors and no people seriously push for their overruling. And I'm answering a lot of questions about Roe, which I think indicates that Roe doesn't fall in that category. And scholars across the spectrum say that doesn't mean that Roe should be overruled, but descriptively it does mean that it's not a case that everyone has accepted and doesn't call for its overruling. I don't
Okay,
think
so here's what's interesting to me. You said that Brown is, and I know my time is running out, is a super precedent. That's something the Supreme Court has not even said, but you have said that. So if you say that, why won't you say that about Roe v. Wade, a case that the court's controlling opinion in that Planned Parenthood v. Casey case has described as a super precedent? That's what I'm trying to figure out.
Well, Senator, I can just give you the same answer that I just did. I'm using a term in that article that is from the scholarly literature. It's actually one that was developed by scholars who are, certainly not conservative scholars, who take a more progressive approach to the Constitution. And again, as Richard Fallon from Harvard said, Roe is not a super precedent because calls for its overruling have never ceased, but that doesn't mean that Roe should be overruled. It just means that it doesn't fall on the small handful of cases like Marbury versus Madison and Brown versus the board that no one questions anymore.
Is United States v. Virginia military, is that super precedent?
Senator Klobuchar, if you continue to ask questions about super precedents that aren't on the list of the super precedents that I discussed in the article that are well acknowledged in the constitutional law literature, every time you ask the question, I will have to say that I can't grade it.
Okay. Well, I am then left with looking at the tracks of your record and where it leads the American people. And I think it leads us to a place that's going to have severe repercussions for them. Thank you.
Senator Sass.
Thank you, Mr. Chairman. Judge, welcome back. I mean this as good news, but it might not feel like it after me. You're half done for today. I'm 11th of 22. Mr. Chairman, before I begin my questioning, I'd like to ask unanimous consent to admit into the record a letter from Alan Gelzo, the historian at Princeton, who has written a letter to the committee in response to some of Senator Harris's claims about the history of Supreme Court vacancies going back to the Civil War.
Without objection.
Thank you. Judge, you have said that the meaning of law doesn't change with time, and you've said that's very important. Can you unpack for us why it's so important that the meaning of a law doesn't change with time?
Sure, because the law stays the same until it is lawfully changed. And if we're talking about a law that has been enacted by the people's representatives, or gone through the process of constitutional amendment or constitutional ratification, it must go through the lawfully prescribed process before it's changed. So Article 5 in the context of the Constitution, or bicameralism and presentment in the context of statutes. And it's not up to judges to short-circuit that process by updating the law. That's your job.
But laws clearly are written in a context, and then the circumstances to which those laws have applied would change. Does the Fourth Amendment have nothing to say about cell phones? Unreasonable search and seizure was obviously not written at a time when they had imagined mobile technological devices that addicted our kids. Does the Fourth Amendment have nothing to say about cell phones?
No, the Fourth Amendment, the Constitution, one reason why it's the longest lasting written Constitution in the world is because it's written at a level of generality that's specific enough to protect rights, but general enough to be lasting, so that, when you're talking about the constable banging at your door in, 1791 as a search or seizure, now we can apply it, as the court did in Carpenter versus the United States, to cell phones. So the Fourth Amendment is a principle. It protects against unreasonable searches and seizures, but it doesn't catalog the instances in which an unreasonable search or seizure could take place. So you take that principle, and then you apply it to modern technology, like cell phones, or what if technological advances enable someone with Superman X-ray vision to simply see in your house? So there's no need to knock on the door and go in. Well, I think that could still be analyzed under the Fourth Amendment.
So I think this is a useful place to explain to the American people again what originalism is and why it's a mistake to view it as a Republican position. I think that originalism is a part of a jurisprudential debate. It's not a part of a policy continuum between Republicans and Democrats. I think it's something that is useful for everybody who believes that three branches of government have two that are political and one that is not. So maybe it's useful to just kind of back up and say, when you define yourself as an originalist, what does that mean? And then how is it going to relate to that distinction between the principles that are timeless, but the applications that are clearly going to change by circumstance?
Right. So originalism means that you treat the Constitution as law because it commits these texts to writing. And in interpreting that law, you interpret it in accord with the meaning that people would have understood it to have at the time that it was ratified. And the reason that you do that is because otherwise, well, as I said, the law stays the same until it's lawfully changed. Otherwise, judges would be in the Constitutional Convention business of updating the law rather than allowing the people to take control of that. Now, in the case of the Constitution, as I said with the Fourth Amendment, many of its principles are more general. Unreasonable searches and seizures, free speech. Those are things that have to be identified or fleshed out or applied over time. So the fact that there wasn't, the internet or computers or blogs in 1791 doesn't mean that the First Amendment's free speech clause couldn't apply to those things now. It enshrines a principle, and we understand the principle as it was at the time, but then it's capable of being applied to new circumstances.
So when you define yourself as an originalist, what are the other schools of thought that are adjacent to it? And how do you think about the debates among those with other people that are now with you on the Seventh Circuit, for instance?
Sure. Well, Senator Sass, I think one thing that it's worth pointing out is that in the academy, in any event, where I've spent a large portion of my career, Originalism is not necessarily a conservative idea. There is a whole school of thought, and so originalists are now a very diverse lot. And there is a school of originalism that's more of a progressive originalism and is very committed to keeping the Constitution's meaning, just interpreting text the way all originalists do, to say that it has the meaning that it had at the time that it was ratified, but they tend to read it at a higher level of generality. So all originalists don't necessarily agree. And in fact, there's an advocacy group called the Constitution Accountability Center, which has routinely filed briefs in the Supreme Court that calls itself, it writes briefs in support of originalism, but taking it from a more progressive standpoint. So I don't think I think probably people think, oh, it's only conservatives who are originalists, but actually it's a more widely accepted view than that. I think that if you think about different strains of approaching constitutional text, originalism is one. All judges and justices take account of history and the original meaning. It's just that some weight it differently, whereas originalists would give it dispositive weight when it's discernible. Other approaches to constitutional interpretation may take a more pragmatic view and say in some instances, well, that may have been the historical meaning, but that's an uncomfortable fit for current circumstances, so we will tweak it a little bit to adjust it to fit these circumstances, that situation. Sometimes it's called living constitutionalism, that the Constitution can evolve and change over time. Sometimes it's called like a more pragmatic constitutionalism.
So I want to make sure we establish this fact clearly together, because one of the things that I think is really unhelpful for the American people when they see hearings like this over the last 20 years is there is an assumption that those of us who've advocated for you over the course of the last 3 years must be doing it because we know something about your policy views, and we've seen the beautiful mind conspiracy theory charts, for instance, that this is about specific outcomes that people want. What I want is to have a judge who doesn't want to take away the job of a legislature that's accountable to the people. What I want is to be sure that the two political branches that are accountable to the people because they can hire and fire us are the places where policy decisions are made. So what you're saying is, in the legal academy, there are people who agree with you on originalism as a broad philosophical school, and yet would come out very different places on the outcomes of particular policy decisions.
That is what I'm saying.
So on the Notre Dame law faculty, when you were up for the vacancy on the 7th Circuit 3 years ago, the Notre Dame law faculty, as I understand, the letter that we got from them here, had people unanimously recommend you across the faculty, and I would assume there's a pretty wide view of policy on the Notre Dame law faculty.
There is.
And so people can affirm that you know what the job of a judge is. You have the judicial temperament and modesty and humility about the calling, and they're comfortable with you, even though they don't think they might agree with every policy view that you have before you put on your robe.
I hope that is what people think of me, because that's what I've always striven to do, and certainly in my time as a judge. My job, my boss, is the rule of law, not imposing my policy preferences.
So can you tell us what the Black Robe is about? Why do judges in our system wear robes?
Well, judges in our system wear black robes, and they started wearing black robes actually because Chief Justice John Marshall started the practice. In the beginning, justices used to wear colorful robes that identified them with the schools that they graduated from. And John Marshall, at his investiture, decided to wear a simple black robe. And pretty soon the other justices followed suit, and now all judges do it. And I think the black robe shows that justice is blind. We all dress the same. And I think it shows that once we put it on, we are standing united symbolically, speaking in the name of the law, not in speaking for ourselves as individuals.
Thank you. You, in your questioning from Chairman Graham this morning, talked a little bit about the process of judicial decision-making, and you started with 4 steps and then added a 5th, and then I think added a 6th. Because it turns out being a reactive branch is really reactive. Can you explain what it means that the judiciary, the Article 3 branch, is reactive?
So Article 3 of the Constitution says that courts can hear cases or controversies. So a judge can't walk in one day and say, I feel like, visiting the question of health care and telling people what I think. We can't even think about the law or how it would apply until litigants bring a real live case with real live parties and a real live dispute before us. And the material that we have to decide that dispute is what comes from you. It's the statutes that you pass. We don't get to come up with the policies and see our wishes become part of the United States Code. So we react to the litigants who bring cases before us, and we apply the laws that you make.
And what are the steps inside those Article III courts before it would ever get to a situation where the Supreme Court hears cases? What is unique about the Supreme Court?
So the Supreme Court obviously sits atop the federal hierarchy of the judiciary. And the Supreme Court, so my court now, the Seventh Circuit, every time someone loses in the district courts, which are the trial courts, they can appeal. And we take every single appeal that comes. The Supreme Court works differently. The Supreme Court takes cases when it needs to. Most frequently, the reason it takes them is to resolve a division among the courts of appeal or the state Supreme Courts. The Supreme Court gets about 8,000 petitions a year, and they hear about 80 cases a year. So it's discretionary what cases to take.
So it's reactive, it's a reactive branch, and it's after a process where there's a statute, it's been challenged, there are active cases, and then it works its way up to the court. But when the justices decline to take a case, what are they saying? They're saying you don't matter and you don't have a right to appeal? What are they saying to the litigants in a case when they decline to grant cert?
They're not expressing any view on the merits. They're simply saying this isn't a case that we're going to put on our docket for certiorari because the court has obviously limited time and limited resources, and so it selects the cases where it's resolving a division, for example, in the courts or some other question on which, of national importance on which the Supreme Court needs to step in.
There has been a lot of discussion in some of the questioning earlier this morning implicitly about standing. Can you just explain what standing is so that the American people understand it?
Yes. So this dovetails with your question about the judiciary being a reactive branch. So as I said, the Constitution gives the courts, the federal courts, the power only to decide actual live cases and controversies. So not only can we wake up one morning and volunteer our views, because the Constitution prohibits us from giving what are called advisory opinions. We can't just dispense advice or give our views on the law, which is one reason why I'm not able to answer some of the questions being asked today. A litigant can't get us to give an advisory opinion or elicit a view unless the litigant actually has a real case. So you, Senator Sass, couldn't walk into court and file a lawsuit and just ask me to give my advice on whether some particular statute was constitutional. I can only decide that question if there is an actual dispute about it.
You mentioned living constitutionalism a little bit ago. I think Chief Justice Warren had a much broader view of standing than some of the folks that have influenced your thinking and writing. Can you walk us through a little bit of the history of the court's view of standing over the last few decades?
So are you thinking about how broadly, like when a plaintiff has suffered an injury or that's a concrete injury?
Right.
So Senator Sass, if you came into court and you were objecting to a particular statute and you didn't like a particular statute, you would have to actually suffer what's called a concrete injury. So the Supreme Court a few terms ago in a case called Spokio said that a plaintiff lacks a concrete injury if the harm isn't, let's see, to use words the American people might understand, palpable. Like it can't just be a procedural injury or something that didn't actually have real consequence or real effect on the litigant. I think that the dispute about standing, or the difficult thing in deciding questions of standing, and the Spokio opinion lays this out, is deciding when an injury is concrete and courts can hear it, or when that injury is more abstract and designed to elicit an advisory opinion from the court.
You said in your opening comments yesterday that it is not the responsibility of the courts to right every wrong in society. I want to ask you a question about it, but first, can you just remind us what your view is there? Why did you say that?
So I think probably what I was getting at there, although I have to say, Senator Saff, so much has happened since I gave the opening statement yesterday. Courts because they are reactive, can't reach out to right wrongs that don't come to them in the case, in the situation of a case or controversy. And then even if they come to courts in the situation of a case or controversy that a court can legitimately decide, we're not free to just resolve it like Solomon in the way that we think is wisest. So we are only free to address wrongs and decide cases in accordance with democratically elected law. So the policymaking is yours to do, and it is only if you have enacted policies that enable us to right a wrong that we can do so.
So you still said, though, that
Hey guys, want to thank you for staying with us this long here. I'm going to let this play out just a little bit longer as everyone finds another place to settle that wants to keep watching this. We're in North Kakalaki here, and we've had 4 days of rain and the sun is out, so we're going to head over to the park. So we're going to put this on hiatus for just a little bit. Want to thank you so much for watching. Jake and myself really appreciate it. Once again, haven't heard anything that would make me not want to vote for this fine candidate. Once again, a wonderful thing that Trump will get accomplished before the end of his presidency or the beginning of his new one, whichever way the vote goes. But thanks a lot for watching, and we hope you'll join us the next time we come on. And anyway, this is Rich, and this is Vantage Point. Thank you much.